I'll call the meeting to order. State Government Policy, Finance, and Elections Committee, today being Thursday, February 27th, 2020. Welcome, everybody. I'm glad to have you here today. We have one bill on our agenda, that is Senator Newman. And so we'll go ahead and get started with that. And Senator Newman, as a member of the committee, I'll leave you to the motions and whenever you're ready. And I understand you have an author's amendment, so if you'd like to do that right away, it's up to you.
Thank you, Madam Chair. I do have an author's amendment. It would be the A3 amendment that I would move at this time.
Senator Newman moves the A3 amendment to Senate File 3571. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Newman, to your bill as amended.
Thank you, Madam Chair. Members, Senate File 3571 is a voter ID bill that I have recently put together. And I thought I'd start out by explaining, why are we going to do this now in 2020? I was the chief author of the constitutional voter ID bill in 2012, and it's a topic that I have really never let go of. I was in favor of it then. I'm in favor of it now. I got to thinking that we have new members in the Senate, new members in the House. We have a new governor, and I just think it would be a good idea to have a discussion with these new people regarding this issue. Secondly, in 2012, there were two constitutional amendments on the ballot. One was the marriage amendment, one was photo ID. The marriage amendment proved to be pretty controversial. And I've often wondered if there was any down ballot negative effect on the constitutional amendment for photo ID because the marriage amendment was on the ballot. We will, of course, never know, but I have to admit that the thought has crossed my mind. Next, if we look at photo ID laws in the state of Minnesota, Indiana came forward with their photo ID statute, and since then there were lawsuits. The Indiana statute went through the court system, and ultimately the United States Supreme Court weighed in on the issue. A number of years have now gone by. It's well over a decade since those events occurred. And so since 2012, we have had a number of studies that have been completed. There's a lot of new data on this topic. And there are court cases that have been decided, none of which we had in 2012. So I just thought that given the amount of time that has elapsed, and this is probably, at least in my estimation, probably the most important reason to bring it forward, is just the data, the studies, the court cases, and the time that has elapsed since 2012 when we looked at this the last time. I will tell you that I have always felt that irrespective of party affiliation, our concerns have always been the same. We as legislators, I sincerely believe, on both sides of the aisle, are very interested in protecting the integrity of our election system. I also think that we are all pretty sensitive to the potential disenfranchisement of voters. And when I say disenfranchisement of voters, I mean not only those who may have a difficult time obtaining the necessary documents, but also the voters who are disenfranchised when illegal voters cast votes and neutralize the vote of a legitimate legal voter. So voting rights, in my mind, although in the Constitution are equal, I really think they're preeminent. If we lose the right to vote, we would lose all of the other rights that we have outlined in our Bill of Rights and would not have the ability to get them back. So I personally will tell you that I take the issue of voting rights and integrity very seriously. And I think it is time that we now have a discussion again on this particular issue. I want to give you a little bit of background historically on the issue of photo ID and voting bills, because I'm going to ask Ms. Stengel in a few minutes to outline the bill for you as written. And if I give you a little bit of context, I think it, at least from my perspective, it will be easier for you to follow what is in this new piece of legislation. If we go back to about the year 2000, you remember the hanging chads and the really difficult presidential elections that we had. Voter confidence, and these are just some studies that I've found, voter confidence began to be decreased. It was lessened. And by 2004, the studies showed that 48% of Americans were confident that their votes were accurately counted, 48%. By 2012, that number had shrunk to 31%. So you see the decline in voter confidence throughout the nation has been going on now since 2000 and forward, and it's at that point that you then began to see photo ID bills. The first one that I am aware of would have been in the state of Indiana. And so Indiana passed its photo ID statute, shortly followed by, of course, litigation challenging the legality, the constitutionality of that bill. And that wound through the court system, ultimately winding up in front of the United States Supreme Court in the case of Crawford versus Marion County. I think it's really important for you to understand the basic legal precepts, the basic legal tenets of the Crawford case in order to follow what I am trying to accomplish in Senate File 3571. First of all, the Crawford case and the justices that wrote the Crawford case decided that the states have a legitimate state interest in voting laws involving photo IDs. And they held these four basic tenets as what legitimate state interests the state had. Number one, deterring and detecting voter fraud. Number two, preventing voter fraud. And the court saw that as sort of voter fraud, but in three separate categories. Regarding voter fraud in general, this is what the court said, and I'm paraphrasing here, but I will represent to you, I believe I'm doing it accurately. The court found that fraud has been documented throughout our nation's history. In-person fraud is not likely common, but it is difficult to detect, and that voter fraud is real and its effects could determine the outcome of a close election. So that's what the court said in terms of voter fraud. Next, they talked about, I'm still in the state's interest in these, or in this statute. The court said that states have a legitimate interest in improving and modernizing election procedures. I'll give you just one example that I thought of in the context of modernizing election procedures. In the 20th century, when we'd go in and get our driver's license, or we would renew our driver's license, we would receive a receipt. I recall it being pink. I could be wrong. Maybe it was yellow. But it was just a yellow or a pink slip of paper that had our name and address on it. In the 21st century, we go in and do the same thing, and we get a receipt, and it has our picture on it, and it has our address on it, and it's not a little sheet of paper anymore. It's an 8.5 by 11 piece of paper. And because we now have digital photography and the ease of transferring photography in the 21st century, we could now use that receipt as a document which would allow you to vote, as opposed to having to wait for the new driver's license that you've just ordered come to you through the mail. And so that's just an example of where we are at in the 21st century, say, versus the 20th century. The final state interest that the court outlined that they had, that states had, was to safeguard voter confidence. And I would draw your attention to the statistics of the decrease in voter confidence in the early part of the 21st century. That's the court is specifically talking about that. And to quote the court, it said, "Public confidence in the integrity of the electoral process has an independent significance because it encourages citizen participation in the democratic process." And I've really zeroed in on the word independent significance. They're not talking about just voter fraud. They are talking about the fact that the more confidence that the people of this nation have in their system, the more likely it is that they will participate in the democratic process, and that is of independent consideration in determining whether or not to allow photo ID requirements for voting. There are three other precepts that I want to outline for you that came out of the Crawford case, and they would be as follows. Crawford held specifically that federal law authorizes states to use photo ID to determine a person's eligibility to vote. And in that respect, the court specifically said, and here I quote, "Election officials need to make sure that the person arriving at the polling place is the same person on the registration list." The next thing that the Crawford case held was that photo ID imposes some burden on voters. But by providing for provisional ballots and a free voter ID card for those who do not have a photo ID card, it is, quote, "not a substantial burden on the right to vote." So here we have the Crawford case specifically saying that if we provide a free photo ID card for people to vote, that does not impose such a heavy burden on those folks that would make the photo ID bill unconstitutional. And then the last thing that I want to bring to your attention is this. The court went on to talk about a specific class of persons who might be adversely affected more so than others. And here the court identified that class of persons. And what they said was, and this again is a quote, "elderly, those born out of state, or have economic or personal limitations to obtain the documents necessary to obtain a voter ID." So here the court is specifying the very people that we are worried about that this would adversely affect. And so what Justice Kennedy said was that this burden against this and this is a very small group of people now that we are talking about, that burden is mitigated by the provisional ballot, and it is mitigated by the fact that if they are unable to obtain the documents necessary to get the photo ID card, they can execute an affidavit at the clerk's office that would allow their vote to be counted. And I think that's really critical, because there is going to be some small number of folks who don't have a photo ID card, a driver's license, whatever the case might be. I think that's going to be not very many. There's going to be some elderly or some disadvantaged folks who are going to have to go out and get the underlying documents in order to obtain that photo ID. I think that's going to be a pretty small number. But even in that case, the court didn't insist that the state pay for those. In this bill that's coming up, we're going to pay for those. So then there's going to be this really small group of folks who can't come up with the documents necessary to get the card. And in the Indiana bill, or in the Indiana statute, there was provided under those circumstances for those folks to sign an affidavit saying, I have tried to get the documents necessary to get the card and I can't get them for this reason. And under those circumstances, having those folks have the ability to sign a sworn statement outlining the fact that they have tried and were unable to do so, their vote will count. There will be no one disenfranchised under Senate file that we are bringing forward here today, because I have included that affidavit. And to be real honest, I'm not sure if I remember including that in the 2012 bill or not, but it's in this bill. In conclusion, I have tried very, very hard to follow the outline of the Crawford case. I think it is the landmark case in the United States on this issue. It is the case that has gone to the Supreme Court. I know that there are other cases that are sort of in the works at this time, but I think Crawford is the landmark case on this issue. But I want to bring specifically to your attention the fact that Crawford only addressed in-person voting. It did not address other types of voting. And of course, in Minnesota, we have no excuse absentee balloting, and we have mail balloting. And so what I have done with Senate File 3571 is I have, at least as best as I could, I have tried to extrapolate the mandates in the Crawford case when it came to this issue of photo ID voting, and extrapolate those rules and apply them to both absentee balloting and mail-in balloting. So when the bill is described to you, you are going to hear Ms. Stengel talk about the in-person voting, same-day registration voting, and then we're also going to talk a little bit about the absentee balloting and the mail-in balloting. But again, I did not have specific guidance from Crawford on those two. And what I've tried to do is take the rules out of Crawford and apply them to absentee and mail-in ballot. And I will tell you that if you think I've missed something, I would sure welcome the input on those issues, because I didn't otherwise have guidance. So the ultimate goal that we had in preparing this bill is that, first of all, we wanted to protect the state interests as identified in Crawford. We tried to minimize the burden on that very small group of folks who are required to obtain a voter ID card, and then provide a method for that even smaller group of voters who are unable to obtain the necessary documents that would provide them with a voter ID card, so that they will not be disenfranchised. At this point, I hope this outline will help you follow as you get into the bill and take a look at it. And so at this point, Madam Chair, if Ms. Stengel could walk us through the bill as amended.
Thank you, Senator Newman. And yes, Ms. Stengel will go ahead now and walk us through the bill.
Thank you, Madam Chair, members, and Mr. Erickson will be helping me out on some of the money sections. As As Senator Newman mentioned, I'll be going through the bill as amended. So Article 1, Section 1 makes it clear that somebody that participates in the Safe at Home program can continue to vote by absentee through that program. Section 2 inserts a reference into the Data Practices Act that points to how data is classified in a later section. Section 3 has to do with the Commissioner of Health and local agencies issuing vital records without a fee or surcharge. And I'll turn it over to Mr. Erickson.
Madam Chair, Section 4 just makes a series of transfers and appropriations since the vital records that can be obtained without charge had some dedicated receipts associated with them. This keeps those accounts and the Department of Health held harmless for providing free records.
Madam Chair and members, picking up with Section 5, you'll see it in a variety of places throughout the bill, and I won't call them out each time. There's simply an addition to a reference to a voter identification card and a list of documents you can use, and this is the first such occasion. Also, Section 5 specifies that when a person applies for a voter ID card, they can not be charged a fee for that application. Section 6 is similar. This prohibits the Commissioner of Public Safety and driver's license agents from collecting any sort of fee or surcharge on a voter ID card. The next section, Section 7, talks about the application for a voter identification card, and it includes a lot of things you'd see on a driver's license or ID card, but it also includes additional items that are necessary to show that you are eligible to vote. And you'll see at the end of this section, the data on these applications is private data on individuals under the Data Practices Act. Section 8 has to do with the $8 filing fee that a driver's license agent may charge. In this case, the driver's license agent cannot charge a person that $8 for a voter identification card. But the commissioner will transmit a payment of $8 to each driver's license agent for each card issued. So that should be a wash. Section 9 has to do with the cards themselves. The cards can be issued to somebody who doesn't already have a state driver's license or ID card and who will be eligible to vote on the next election day. There are a variety of things about what must be included on the card and what the card looks like. This type of card is only valid for election-related purposes. Section 10 has to do with when a identification card expires. In general, it expires in the same manner as a regular ID card. It's 4 years after the issuance, unless it's for a person over 65, and then it's 8 years. The provision at the bottom has to do with people that are serving in the military, active duty, or their spouse, and that allows an extra period of time before their IDs expire. Section 11 requires a person who moves or changes their name to obtain a new voter ID card with that new information. Section 12 talks about cancellation of the voter ID cards, and the commissioner must cancel the card issued to somebody who is not entitled to that card. Section 13 sets forth the documentation you can use for identity and residence, and this is largely, I think, shorthanded as the types of photo IDs that are accepted. So you'll see a list of a variety of documents. Each document has to have the person's photo and address on it, or in some cases, you can use two documents to prove those two things put together. The next, skipping over to Section 14, I'll turn this back over to Mr. Erickson.
Madam Chair, Section 14 creates a voter identification card account in the Special Revenue Fund. Money in the account can be used for three things as the bill has been amended. One is to reimburse individuals who have to obtain documents to obtain a voter ID and couldn't obtain one that's mandated to be free under the rest of the bill. The account is also used to provide voter identification cards to individuals who qualify, and it is also used to reimburse driver's license agents for the foregone filing fee.
Madam Chair and members, Section 15 amends the provision on Election Day registration that it eliminates the current process for Election Day registration where you can prove residence, and instead requires you to prove identity and residence by showing one of the photo ID documents as permitted in the earlier section. Section 16 has to do with the polling place roster. In general, your address has to be your residential address on the polling place roster unless you are in the Safe at Home program, a law enforcement officer, correction officer, or judge, in which case you can use a mailing address. Section 17 has to do with, so now these next several provisions will be with absentee ballots. So this has to do with an application for an absentee ballot, and before approving that application, the county auditor or municipal clerk has to verify that the number provided, your driver's license, state ID, voter ID, or social security number is valid and assigned to that applicant. There is a new section that doesn't appear in the bill draft, but does appear in the amendment that requires a voter submitting a registration application with an absentee ballot to prove identity and residence or sign an affidavit saying that they attempted to get an ID but could not. Section 18 has to do with the certificate on the back of an absentee envelope. So that's the signature envelope, and that's where people fill out their information. And this makes some changes to the witness oath. And as part of that process, the voter has to show to the witness proof of identity and residence, and then the witness has to look at that document and then indicate what documents were received. Alternatively, somebody can execute the affidavit that I mentioned recently saying that they don't have an ID. And also, under the amendment, the witness must provide their driver's license, ID, voter ID, or social security number on that oath. The next part has to do with an absentee voter filling out the ballot, and this couples with the last section. It requires the voter to present that proof of identity and residence or execute the document, or execute the affidavit. In the amendment, you'll see there's a new insertion of paragraph C, and this is where the affidavit is described that says you attempted to get a voter ID card but were unable, and you have to list the reason why, and that's a sworn affidavit. The next portion has to do with absentee ballot boards when they are reviewing the envelopes to accept or reject. One of the things they have to look at before an envelope can be accepted is that the witness properly completed that oath and list documents that are acceptable proof of identity and residence. Section 21 and 22 I'll cover together. These have to do with mail ballot precincts. There's a reference to existing rule as to how these are conducted and basically treats them similarly to the absentee ballots, requires the voters to present proof of identity and residence in the same manner as required for absentee voters, and cross-references back to the section we just talked about. And then the signature envelope must have that same witness oath on it. Section 23 amends the Voters' Bill of Rights to include a reference to proving identity. Section 24, and I should say now, this is back to not absentee voting, so this is voting on election day. Section 24, before a person shows up to vote, or before a person can sign the roster or voter signature certificate, the judge has to require the voter to present proof of identity and residence. And an applicant that does not present adequate proof of identity and residence is allowed to cast a provisional ballot. And the details on that are coming in the next section. So section 25 is the section that establishes provisional ballots and how this will work. So a voter that casts a provisional ballot, it's in a series of envelopes very similar to an absentee ballot, and provisional ballots are set aside and kept separately. As part of this, at the polling place, the election judge must inform voters on the process to have their ballot counted after the election. When a voter casts a provisional ballot, they may appear personally before the county auditor or municipal clerk within a week following the election to prove their identity. And if at the time they show up and they can prove that they are eligible to vote, that they show the proper proof of identity and residence, or execute the affidavit saying they don't have a photo ID, and the data matches the identity that was shown and the information on the provisional ballot, then that ballot must be accepted. If it's accepted, it is put into the provisional ballot, accepted provisional ballot pile, and they are opened later. If these requirements are not met or the person does not show up, the provisional ballot is rejected, and the auditor or clerk must notify everyone who has a rejected absentee ballot. At the close of business on the 7th day after the election, the clerk or auditor have to reconcile the ballots, which means they have to make sure that the number on the roster meets the number of ballots they have, and if not, excess ballots are then randomly removed from the pile of accepted provisional ballots. Once all that is accomplished, the ballot envelopes are opened and deposited in the appropriate ballot box and counted in the results. The next several sections have to do with the canvassing timeline. Canvassing has to start on the 8th day or later in order to accommodate counting all of the provisional ballots. So you'll see several provisions here that start canvassing on the 8th day after the election and make appropriately corresponding time changes. So I'll skip over all of those, but if anybody has questions in detail, I can come back to those. And I'll turn it to Mr. Erickson for Section 33.
Section 33 is just a conforming change to recognize an additional source of revenue for the Children's Trust Fund for the Prevention of Child Abuse, which was one of the accounts that had a dedicated receipt from Vital Records, just a conforming change.
Madam Chair and members, Section 34 requires the courts to provide free certified copies of court orders, decrees, and records that are necessary to attain a voter ID card. Section 35 requires the Secretary of State to contract with a vendor for producing a public education campaign about the requirements of voter ID. Section 36 requires the Secretary of State to report back to the legislature with proposed legislation for any necessary rule changes that would be need to be made to administrative rules. And those changes would be in the form of a codified law instead of rulemaking. Section 37 requires the Commissioner of Public Safety to provide training for the driver's license agents that will be issuing and processing voter identification cards. And Mr. Erickson will take Section 38.
Section 38 is the appropriations section. It makes 3 appropriations, all of which are currently blank. The first paragraph is from the general fund to the Secretary of State to implement the requirements of this act. The second paragraph is an appropriation to the Commissioner of Public Safety to make for the programming costs in the driver's license systems. And it currently says to make payments to driver's license agents. That has been shifted into a statutory ability under the voter identification card account. And finally, to train driver's license agents on the new system. And the final paragraph is an appropriation to the Commissioner of MMB to make a transfer into the voter identification card account that already has those statutory purposes articulated.
Madam Chair and members, Section 39 repeals a provision related to recording attempted registrations on Election Day, and Section 40 is the effective date. So generally, this article is effective on June 1st, 2022. Earlier throughout the bill, you would have noticed several of the provisions relating to the IDs go into effect June 1st, 2021, and then the appropriations is effective sooner than that. And then Article 2 is a series of conforming changes throughout driver's license chapters and election chapters that simply inserts the phrase voter identification card in several places where you can use that. And unless somebody would like me to, I'll leave Article 2 with that.
Thank you, Ms. Stengel and Mr. Erickson. I appreciate that. Senator Newman, do you want to add something before we go to questions? And, well, Senator Jasinski, did you have a specific question right now that you wanted to ask?
I did. Thank you, Madam Chair.
Okay.
And I believe it's from Ms. Stengel on page 9, under section 12, line 9.21. It's just a question. Should the commissioner, should that be may or must? I'm curious why it would be may versus a must. And then again on line 9.27, the commissioner shall versus the commissioner must cancel. Just could you address those 2 issues, please?
Ms. Stengel?
Thank you, Mr. Chair, Madam Chair and members. That's a good question, Senator Jasinski. I'll have to do a little looking further. That subdivision 1 applies to the current driver's licenses, and I'm not sure why the may versus must is there. I'll get back to you on that. But for the cancellation of voter identification cards on 9/30, it is a must, so the card must be required if these things happen.
Thank you.
Thank you, Senator Jasinski. Senator Newman, Then we'll go to testifiers.
Yeah, Madam Chair, I have nothing further. So,
Okay, thank you, Senator Newman. With that, we'll go ahead and go to testifiers. We have Secretary of State Steve Simon as our first testifier. Welcome to the committee, Secretary Simon. Then it appears as though we also have your elections director, Mr. Maeda. But Secretary Simon, do you want to start off?
Thank you, Madam Chair.
Okay,
and
just go
members. I
ahead.
appreciate it.
And again, for the record, always your
Yes.
name and title.
Yes,
It's an
Steve
honor.
Simon, Minnesota Secretary of State. Thank you, Madam Chair. Thank you, members. Thank you, Senator Newman. With me today is David Maeda, our Director of Elections. He's happy to stand for any questions you have about some of the more technical aspects about what we do with the state of Minnesota election law, and also because I can't stay for super long. So, but you're in very capable hands with him. We obviously have a difference of opinion here as to this issue. And I think the case in 2012 is the same as the case today, at least in my judgment, which is when it comes to these kinds of proposals, the more you look, the less you like. Voter ID has a surface appeal. There's no question about it. It's natural. It's totally understandable. After all, you need to show a photo ID to buy a beer or board a plane, and I think that resonates with a lot of people. But the bartender or the TSA agent doesn't care whether the ID you show shows a current address or whether it's even from the same state. You could go to a liquor store right now with your California driver's license or your Connecticut driver's license, and you could get that beer, or you could get whatever you wanted. And voting is a constitutional right, so we expect better and we expect more. Senator Newman said that in his judgment, there would be very few people affected by the absence of an ID. That's not our experience. Right now, in the SVRS alone, there are 95,000 Minnesotans that don't have a driver's license. Keep in mind, that does not include other Minnesotans who aren't in SVRS, who maybe weren't 18 as of the last election, or who otherwise didn't vote, who don't have a driver's license. So the figure, I think, would be substantially higher. And it doesn't include those who are in SVRS who originally registered with a valid driver's license, whose driver's license is no longer valid. I don't have the number for you, but surely it's much, much higher.
Secretary Simon,
So-
sorry to interrupt, but we would like to hear you better.
Okay. Better?
There you go, much better.
Okay. We were just talking about the numbers of folks who might be affected, and in our judgment, it's higher than the 95,000 who are now in SVRS without a driver's license. So I think Minnesota voters came to the same conclusion in 2012. I don't think they didn't read the fine print. I don't think they misunderstood. I don't think they were influenced by the fact that this was a constitutional amendment versus a statutory change. All the polling at the time, at least, that I was privy to, showed that they just didn't like the idea. So the bill before you, I think, is an attempt at a do-over. But I think the same principles apply. The problem of improper voting in Minnesota is very small. It is isolated, it is contained, and we know that in part because law enforcement does their job. They do the work. And under state law, as many of you know, they must investigate. There is no discretion. They must investigate all unresolved voter registration and voting records that the counties, cities, and townships turn up. And they have come up with very few charges and even fewer actual convictions. Now, there are some people, hopefully none in this room, but some people out there for whom that will never be satisfactory. If the convictions in some states are high, they point to that as a problem, but in Minnesota, where the convictions and even the charges are very low, they think that's actually evidence of a problem. That the fact that we have low convictions and low charges is evidence of a conspiracy and a cover-up involving who knows who. Sometimes it's our office, sometimes it's county and city elections administrators, and that really is the narrative, that that's proof that there's a problem, that there aren't high convictions and that there aren't high charges. So the only species of voter misconduct that this bill would solve, and that photo ID would solve, is voter impersonation. Any other kind that you can think of wouldn't be addressed, much less solved, by this bill. And I've asked around, including Mr. Maeda, who's been around the block a time or two, and no one I've asked can remember a single case of voter impersonation in Minnesota in the last 20 years. They can't find one. Maybe there is one, but they can't find it. So that's the only thing that this would really address. And my concern is that the bill, if enacted, would have the risk of shutting out hundreds of thousands of eligible Minnesota voters, not ineligible, hundreds of thousands of people who meet all the criteria, who are 18, who are residents of Minnesota, who are citizens of the United States, who are not currently serving a felony sentence, and who wish to vote but couldn't if this bill were enacted into law. So many states, I think, do better, even those who adopt photo ID. Even Mississippi had the compassion, and you don't often hear those two words in the same sentence. They had the compassion to exempt all residents completely of nursing homes and assisted living communities. I remember doing a test at one point when I was in the legislature and going to assisted living and nursing homes and just doing a random sample and asking people in a room, how many of you have a current ID that is not only current, but reflects this current address where you currently reside? I never got more than half the people in the room, ever, in all my time in the legislature who raised their hand. So this bill does, to Senator Newman's credit, attempt to deal with that through a certification process. But what happens, I would ask, if a resident moves even a block to a different kind of care in a different building with a different address? Maybe they go from assisted living to nursing home to memory care, et cetera. The answer, as I read it, is they have to push that boulder up the hill again. Section 11 of the bill says they have to get a new ID card if there's a change of residence at all, and that is troubling to me. Provisional balloting, another issue, one that there is widespread disagreement about here in this room. I have said before that this would, for the first time in Minnesota history, create a maybe pile when it comes to elections. There's the ballots we'll count, the ballots we know we won't count, and then there's the maybe pile. And in this bill, the onus is on the voter. The voter must physically do something, must show up to a county office within a week of election day. And that's a hardship not only geographically, but to those who are voters with a disability. You know, for me personally, I pass downtown Minneapolis every day on my way in from Hopkins to St. Paul. I'd have to go to the Hennepin County Government Center. It would be a pain. I'd roll my eyes, pay a fortune for downtown Minneapolis parking. But if you're in many of the counties you represent, if you're in St. Louis County and you're not in the Duluth area, you're taking the day off of work. And so it's no wonder that nationally, statistics show that as many as 85% of provisional ballots are never counted. And the reason is one of common sense. First, people don't want to deal with the hassle. I can tell you in my line of work, it's tough enough getting people to vote, particularly young people and people in certain communities. You add this to it, they're not going to bother. Secondly, all the results are known, usually by election night. Unless there's a recount, the results are known. And the chances of someone going in within a week to go to a county auditor or some official's office when they know the results of all the election and they are not recount worthy is very, very small. So that, it seems, accounts for the very, very high number, the overwhelming majority that are never cast or counted that are originally cast as provisional ballots. I want to talk just a little bit about documentary proof of citizenship. This is rare. Only a few states have attempted it. Georgia, Alabama, Kansas, sort of Arizona in some areas. It's very rare in this country, and I would submit it's quite harsh. All the states in the country require that someone be a citizen and attest to that fact, but only a very few require documentary proof. And when you look at the literature out there and what's been written about that, many eligible voters lack documentary evidence of their citizenship sufficient to satisfy state proof of citizenship laws. Those most likely to be affected by these laws are students, the elderly, and citizens with a disability. Most vital records offices require individuals to already have another form of government-issued ID in order to get a birth certificate online or by telephone. So imagine the catch-22. You live in Minnesota under this law, but you were born in Nebraska, and you reach out to Nebraska to get that birth certificate of yours, which maybe you've never seen, and they say, great, if you want to do that online or by phone, please give us your driver's license number, or please give us some other form of government ID. So that causes a lot of problems for people who need a birth certificate and who don't have one. The bill gets rid of vouching, at least that's my read. Vouching has been a key part of our success in Minnesota in opening the door to all eligible voters. It's personal to me. In 1998, my parents moved from the house I grew up in Hopkins. They downsized, they moved to another city, and they moved in late October. Not only did they not have driver's licenses that matched their new home, they also didn't even have a utility bill at that point. So my dad could not have voted in the 1998 election, which he did, without having a neighbor vouch for him. So I know that the real world value of that. There are new requirements in this bill for absentee voting and mail-only voters. And it seems to create another hoop or hurdle. It says that now, if you're mailed a ballot to your home, whether it's because you chose to vote absentee or you live in a jurisdiction where they only vote by mail, you will have to not only have a witness, which you already had to, but that witness will have to vouch for or verify a certain form of ID. I don't think that's going to happen very often, and it might sort of subvert the purpose of the bill. I don't think, Ma's going to look at Pa's ID necessarily. They're probably going to say they did, but will they really? I'm not so sure. So, you know, we have 145,000 people in Minnesota who vote in places without polling places, and I just don't know if they would actually comply with this. The only final thing I wanted to say was about Safe at Home. Well, I appreciate the accommodations that Senator Newman has made for Safe at Home. We're uncomfortable with the fact that for the first time in the history of the program, they would be listed on the roster. I realize that they would be able to use their Safe at Home P.O. box, but listing them on the roster, which they've never had to before, is problematic. The bottom line, though, the real view from 30,000 feet, in my judgment, is that we have a system in Minnesota that is, across decades, across secretaries of state, tested and is trusted. And Minnesotans know that our elections show integrity and accuracy. And one of the reasons that we know that is people vote in such high numbers. We were number one the last 2 elections in a row in voter turnout. And before that, for a long string of elections, across secretaries of state, across the years and decades, we've been number one in voter turnout. I just don't think, as a matter of common sense, people would vote in such sky-high numbers if they truly, sincerely believed that the system was riddled with fraud. They just wouldn't do it. I wouldn't. I don't think most of you would. What a waste of time. Why would you endorse or vote in a system that you thought was just kind of an invitation to criminality? People get this stuff. And I think they voted with their feet, and they showed up in such large numbers, in part, at least in part, because they know that basically the system is a good one. They may have ideas about how to reform it, but they know that it's true, and they know that it's honest. So Minnesota regularly requires people who register, all people, to do 2 things. They have to show they are who they say they are, and they live where they say they live. But the beauty of that system is we aren't hooked on just using a government-issued photo ID. There are an array of ways that people can do those things, and that has served us very, very well. I would just close with this. It seems to me that every doctor and every nurse every day has to make a decision about whether a proposed cure is worse than the disease. And in my judgment, the proposed cure here is far worse than the disease. The disease is contained. The disease is controlled. And this is a proposal, and others like it, which risks kicking out and shutting out and fencing out hundreds of thousands of eligible Minnesota voters to catch a couple dozen. So, as in 2012, in my judgment, the more you look, the less you like. That's why Minnesotans rejected this idea in a statewide vote, even though it was polling in the 70s the summer before. The more they learned, the less they liked, and I think that would be true again today. Thanks for your time and attention. I really appreciate it.
Madam Chair.
Senator Newman.
Thank you very much, Madam Chair. And before Secretary Simon has to run off, I want to acknowledge his arguments. He is obviously a skilled orator. But let me just say this about a couple of the points that he has raised.
Senator Newman,
number
speak
one-
right into the microphone. We're having a hard time.
Am I not doing that?
Not quite. Not quite.
We're both learning. The argument that hundreds of thousands of folks are going to be disenfranchised by photo ID is the very same argument that was raised in the Crawford case. And it proved to be unsubstantiated. And in point of fact, in that case, the trial court specifically rejected that argument because the plaintiffs didn't prove it. And I sincerely question the allegation that hundreds of thousands of people are going to be disenfranchised by this bill requiring photo ID. I simply don't believe that the numbers are present. Secretary Simon spent some time talking about the very, very small number of illegal voters. And I acknowledged that in my presentation that illegal voting may represent a very small number of people. But again, remember, in Crawford, they talked about the fact that very small numbers of folks may be actually casting illegal votes. But illegal voting is only one of the 4 legitimate state interests that a state has on this issue, just one out of the 4. And I have, Madam Chair, statistics on some of the really close elections that we have had in the last few years where there is less than 10 votes that have determined the outcome of an election, you can go online to the Minnesota Legislative Reference Library and pull this up yourself and look at it yourself. But going all the way back into territorial times, these close elections have happened. And we right now have a number of sitting representatives, sitting senators, who underwent and went through very close elections. The closest one that I can think of is District 8B, separation of one vote. So the point the Crawford case was making, even though there's small numbers of potential illegal voters, it can affect the outcome of the case. Remember the Norm Coleman and Al Franken election? I think that the percentage of difference in that case was 0.01% out of almost 300 or almost 3 million votes cast. As to provisional balloting, Madam Chair, you're going to know this number better than I, but I think 34 states in the nation have adopted provisional balloting. And the Crawford case specifically acknowledged that provisional balloting satisfies one of the problems in terms of the burden that Secretary Simon says is going to be cast on these people. There is nothing wrong with provisional balloting. It is an accepted practice throughout the United States.
And Senator Newman, that's 47 states.
Okay, I stand corrected. And then finally, the documentary evidence that Secretary Simon testified to. I think it's really going to be, as he indicated, not very many people that are going to be able to be unable to come up with the necessary documentary evidence. But for those who can't, it will be a burden. And that burden was acknowledged in Crawford. And so what we have taken is the approach of acknowledging the burden, acknowledging what the state of Indiana did, and provided for those few people who can't come up with the documents, they are not disenfranchised. They simply have to sign an affidavit under oath saying, I have tried to come up with this documentation. I cannot get it, for whatever the reason might be. And under those circumstances, their ballot counts. They get to vote. And so to each of those points, I just wanted to reiterate and respond to Secretary Simon's testimony.
Thank you, Senator Newman. With that, we have another testifier.
Madam Chair.
Yes.
Madam Chair.
Senator Coran.
Thank you, Madam Secretary. Simon, quick question. So when we talked about the transparency, accuracy, and some of the challenges that citizens have today, when you look at the OLA report from 2018, and I think the statement is, as of August 2017, fewer than half of the people charged or persons charged with registering and voting that are ineligible to vote over a 5-year period, only 47 of the 132 were even charged with a felony. And so I think those types of statistics add up, that every vote does matter, every legal vote matters, and we want to make sure that all of them have the legitimacy to vote, and those that don't are actually tried and convicted. And so when you have less than half even charged at the statutory requirement of felony level, that doesn't, that disenfranchises a lot of legitimate legal voters. So.
Thank you, Senator Coran. We have our next testifier, Mr. Page. Welcome, Mr. Page. Again, for the audio record, your name and title.
Thank you. Thank you, Madam Chair and members of the committee, Senator Newman. My name is Justin Page, and I'm an attorney at the Minnesota Legal Aid and the Minnesota Disability Law Center. The Minnesota Disability Law Center is a state protection and advocacy organization for individuals with disabilities in Minnesota. Our office receives a grant through the Help America Vote Act to conduct nonpartisan voting rights work. Part of the work we do is to train individuals with disabilities on their voting rights in order to increase their access to the polls. I want to concur with Secretary Simon in that we do a lot of training, and I've personally done a lot of training in nursing homes and group homes, and it's rare that an individual has their current ID with the address where they live in nursing homes and group homes and assisted living facilities, based on my experience. Based on my research into voting rights issues and the experience training people on their voting rights, the good news is that individuals with disabilities are eager to vote. The not so good news is that individuals with disabilities still face significant barriers in exercising the right to vote. According to a report from the Rutgers School of Management and Labor Relations that came out after the 2018 election, there was a 4.7-point gap in voter turnout between citizens with and without disabilities in 2018. To put that another way, if people with disabilities voted at the same rate as people without disabilities, there would have been 2.3 million more votes in the 2018 elections. The Disability Law Center is concerned with the photo ID legislation because it would present a barrier and discourage people with disabilities from voting. People with disabilities are less likely to drive and less likely to have valid current photo ID than the general population, and they face significant barriers in getting one. Individuals with disabilities who do not drive may have trouble getting transportation to a government office to get an ID. Accessible transportation is a huge issue for individuals with disabilities throughout the state. According to the Rutgers report I mentioned earlier, people with disabilities were more likely to cite transportation problems as a reason for not voting and less likely to say they were not interested in voting. Because people with disabilities currently have barriers in getting to the polls, we believe adding a photo ID requirement would only compound the problem and make it more difficult for people to vote. Therefore, we ask you to oppose this legislation. Thank you.
Thank you, Mr. Page. All right, members. Senator Westrom.
Madam Chair, Justin, I think you said your name was?
Mr. Page, yes.
Mr. Page, you mentioned the requirement of the photo ID would be a difficulty for somebody with a disability. Can you expand on that a little bit more? Because under this bill, it would offer free IDs if somebody doesn't already have one, but
right.
Many times, I mean, anybody that's either traveled, cash checks, I'm not sure I follow your thought on, there's many people with disabilities that would have an ID already, even though they may not have a driver's license. And so this would offer them a free one if they didn't. Can you expand on that a little bit more?
Mr. Page.
Thank you, Senator, and I totally agree. There's a lot of people with valid photo IDs that this would not present a problem with. But I'm going back to the Rutgers study, which says voters with disabilities are almost a 5-point voting less, 5 percentage point than voters without disabilities currently. And the issue is transportation and getting to the government office. We just think that would be an extra barrier for a lot of individuals with disabilities who don't have access to transportation in the state.
Senator Westrom.
Madam Chair and Mr. Page, I guess I'd take issue with, you make the assertion that the need to show that ID would somehow take somebody with a disability and that would be the deciding factor, or that would make them want to vote less. Not legitimately. Why would they want their vote watered down or changed potentially because somebody that wasn't legitimately voting affects their vote. And so you can make that statement, but I just don't see any substance behind why you think somebody showing that ID, which in many cases they already have, and they've shown it in many other aspects of their lives. I think it's a little far stretch, and there's a point where we need to raise the expectations, and I think you're maybe stretching it a little bit to try to use the disability category as the reason for no photo ID, but I don't see the connection legitimately behind what you're saying, and I don't think you've offered any evidence that, other than an opinion, that that's somehow going to have those people not want to vote. So I'd just caution you to making those types of connections, because I don't think it's more than just an opinion. And so I'd just raise those concerns.
Thank you, Senator Westrom. All right. Okay. With that, we'll go on to Mr. Mohammed. I'm sorry, Senator West, I didn't see you.
Senator Newman made a comment about the number of states that have some sort of provisional voting or voter ID, and then you made a similar comment. And I wonder if you would provide the members with a list of those states that you said it was 47. So which 3 don't, or which 47 do? If you could send us a list of those. There's some dispute when you look it up on the internet of how many states actually have that requirement. Thank you very much.
Senator West, I'll respond to that since I'm the one that gave the number 47. That's provisional ballots. Provisional ballots is a part of this bill. 47 states have provisional ballots, but as far as the ID requirements, Senator Newman's number stands.
Madam Chair, I'm just requesting if you would send us a list of those states. Thank you very much.
Thank you, Senator West. Appreciate that. Okay, our next testifier is Ms. Mohammed. Welcome to the committee, and again, for the audio record, like you've heard with others, your name. And I have on here that you're representing the ACLU Minnesota. If that's the case, just state that also for the audio record.
Thank you, Madam Chair and Senate members. My name is Manira Mohammed, and I'm the Policy Associate for the ACLU Minnesota. I'd like to begin by saying that voting is the cornerstone of our democracy and a fundamental right upon which our civil liberties rest. The ACLU works to protect and expand Americans' freedom to vote through litigation and advocacy around the country and across this great state. The fight for voting rights remains as critical as ever. Minnesota is justly proud of its high voter turnout, yet this bill would deprive many voters of their right to vote, reduce participation, and exclude people from the democratic process. Why are we looking at a bill that would repress voting, a hallmark of a healthy democracy? The voter ID provision of this bill targets voters who are disproportionately low income, racial and ethnic minorities, Native Americans, the elderly, people with disabilities, and students. Such voters already have difficulty obtaining ID because they cannot afford or cannot obtain the documents needed to get a government-issued photo ID. Senate File 3571 also introduces the use of provisional ballots into Minnesota's election process. It would end Minnesota's longstanding system of allowing all challenged voters to swear an oath that they are eligible to vote, with the consequence of a felony conviction if they are not eligible. There are many reasons the information regarding a voter could be inaccurate and not verifiable between voting and ballot counting. We're concerned that many Minnesotans will have their vote incorrectly voided. A voter ID law and provisional ballot system would undermine Minnesota's established process, which is fair, efficient, accessible, and reliable. People across the state are overwhelmingly in favor of same-day registration. Why make voting harder? The ACLU of Minnesota respectfully urges you to oppose Senate File 3571. Thank you.
Thank you, Ms. Mohammed. Appreciate your taking the time to come today.
Madam Chair, if I may respond.
Senator Newman, yes.
Yeah, if I may respond very, very briefly. The allegation is that with voter ID, minority groups are systematically discriminated against and disenfranchised, and I would assert that the information that I have seen shows no significant difference in voter participation by minorities after a voter ID law is in place. And that, if you go back to my original presentation, where I was talking about that very issue. And in point of fact, something that I discovered that I found really interesting, and it surprised me, insofar as the Hispanic vote is concerned. And the information that I found is that Hispanic voting actually increased with photo ID laws being put in place. And the thinking is that in many Hispanic countries, photo ID laws are already in place. And those folks who come to the United States and become citizens are already used to having to show a photo ID. They already have the documents necessary and have indicated a certain amount of civic pride in when they go into the voting place being asked to show their ID that they are now American citizens. And I just thought it was a really kind of an interesting sideline to the allegation that minorities are systematically disenfranchised. The information that I found says that allegation is not true.
Thank you, Senator Newman. Interesting information. Appreciate that. Senator Rest?
Thank you. Again, Senator Newman, would you provide us the source of the assertion and allegation that you just made? We'd appreciate receiving that and knowing how valid that information is. Appreciate it. Thank you very much.
Senator Newman.
Madam Chair, that's a reasonable request. I would be more than happy to do so.
So, Senator Rest, you want to verify that information, is that correct?
I would like to know what research was done, who was the author, where was it published. I think that's a reasonable request.
Yeah, Madam
Thank you,
Chair,
Senator Rest. Senator Newman?
my LA is in the audience. I've already turned around, and he has given me the thumbs up. We will provide you with that requested information.
Thank you, Senator Newman. So the next testifier that we have today is Katrina Mortensen. Ms. Mortensen, welcome. I know you've heard it before, but again, your name and the group you're representing for the audio record.
Thank you.
And lean into the microphone. We want to hear you.
Yes. Thank you, Chair Kiffmeyer, members of the committee. My name is Katina Mortensen. I'm the Director of Public Policy at the Minnesota Council on Foundations. The Minnesota Council on Foundations is a membership association of grant makers across the state. There are about 150 grant makers made up of community foundations, private family foundations, and corporate foundations and giving programs. And MCF and its members work towards a more prosperous and inclusive Minnesota. And the reason I'm here today is about the inclusive piece. So when we think about inclusion, we think obviously about making sure that historically disenfranchised people feel welcome and a sense of belonging. But the other piece of inclusion is people feeling like they are actually included in decision making. One of the key places where we make decisions is in elections. Elections are a way for the community to make their voices heard and to elect their representatives who will address their concerns. So today I'm here to voice our opposition to this bill. Voting is a civil right, and in our understanding, this bill will reduce access to the ballot for some Minnesotans and make our election system less inclusive. As we've heard today from some other testifiers, certain communities would be disproportionately impacted by this bill, including students, the elderly, low-income individuals, and people with disabilities. I would also point that this was brought directly to the voters in 2012, and they decided against it. So I ask the committee to oppose this bill, and thank you for your time.
Thank you very much, Ms. Mortensen. Appreciate you taking the time to be here today. Senator Westrom.
Madam Chair, Ms. Mortensen, can you give us more concrete examples of how this is going to disenfranchise voters? Again, it sounds like an opinion of yours, but substantively, what is it that you're pointing to that's going to disenfranchise? Because there is free IDs if money, and we don't want the cost of an ID to be a burden. So that's why we've dealt with it. But it just seems like there's not any concrete facts behind what you're stating, and I'd like to know that if you could.
Ms. Mortensen.
Yep. Madam Chair, Senator Westra, members of the committee, I would point, I think the expert on this would be Secretary Simon, and he was able to point to some of that. I would say just from personal experience, thinking about even neighbors or others that I know who don't have IDs, I know that even if the cost isn't a barrier, sometimes the time to get one is a barrier, the level of effort it would require. So I think for different sets of people, different reasons would be the barrier, and I don't think cost is the only barrier that people would face.
Thank you, Ms. Mortensen. Ms. Mortensen, I just wanted to be sure, though, that in recognizing that it wasn't just the free ID, it was also the underlying documents as well. So I just wanted to be sure you understood that is there as well. Thank you, Ms. Mortensen.
Thank you.
Thank you for coming. Our next testifier is Mr. Harper. Mr. Harper, for the record, again, your name and group or title. Thank you.
Yes, thank you, Madam Chair. My name is Nick Harper. I'm the Civic Engagement Director for the League of Women Voters of Minnesota. We're here to ask the committee to vote against this bill today. Obviously, election integrity and preventing voter fraud is an important goal, as is increasing trust in our elections. But unfortunately, this bill will reduce that confidence and integrity in our elections in the end. I appreciate that Senator Newman reviewed the information about the Crawford case. As an attorney myself, I think it's very important to review that information. First, the first piece of information that I'd like to address is that Senator Newman noted that the court didn't have substantial information showing that voters would be disenfranchised by the voter ID law in that case. And there appears to be several questions about that from members today about where that evidence is and how it exists. I did submit some written testimony for the committee today. I don't think it got into the packet because I did not meet the deadline, and apologies to members for that. But I will make sure that you all receive that information. It does have some excellent citations to research that has been done over the years since the Crawford case that does demonstrate the effect of voter ID and its negative impact on eligible voters from casting a ballot. In addition to that, I do want to also note that there has been discussion over the existence of voter impersonation fraud, which is the only type of fraud that this bill would address, would be impersonation fraud. And you don't have to believe, the League or me or the Secretary of State's office. You can look to the Heritage Foundation, which is a conservative think tank organization that has done significant research on voter fraud and election integrity. And even their report on voter fraud has not found any evidence of voter impersonation fraud in Minnesota. So there is no evidence that this is a problem that needs to be addressed. In addition to that, I do appreciate that members are drawing attention, and Senator Newman has drafted this bill so that there are no fees associated with purchasing an ID or the documentation underlying that ID, and that is appreciated. However, that's not necessarily sufficient. One of the cases that's actually happened recently since the Crawford case is One Wisconsin Institute v. Thompson, which was a federal court case in 2016. And that court actually said that even though the fact that Wisconsin had made their voter IDs free, it was not sufficient in saving that law from an injunction from the court. The judge eventually found that because there were significant logistical costs and because of the complexity of the execution of the law, that it was confusing to voters, that was sufficient to be a burden on voters in accessing the ballot. So I appreciate that we're having this discussion today, but I wanted to provide some of that additional information to members that would be relevant to this bill.
Thank you very much, Mr. Harper.
Madam
Senator Newman.
I would just want to address one issue that Mr. Harper stated, and that has to do with the Wisconsin case. Ms. Stengel, I want you to correct me if I'm wrong, but I believe that the Wisconsin case that Mr. Harper cited is still in process of going through appeals, and so that case has not yet finally been decided.
Thank you, Senator Newman. Senator Newman, if there were a stranger in front of you and they claimed to be a certain person, how would you know that they were who they say they were? Senator Newman.
Well, I think that the best evidence, the best tool that we possibly could have would be the government-issued photo ID. Now, and I specifically say government-issued because I think to come up with any sort of a photo ID, could be doctored. But what we're talking about here is the identification of the person and their proof of residence. Those are the two important pieces. I don't think anything, quite honestly, is absolutely foolproof. But in all likelihood, the best tool that we would have available to us to prove exactly what you are talking about would be the government-issued ID that is the subject of this bill.
Thank you, Senator Newman. One of the things, another question I have for you, Senator Newman, when you and Senator Cran, I'll be right there. Senator Newman, it was stated here that it's a constitutional right. Senator Newman, it is a right to vote, but Senator Newman, doesn't the Constitution also have some requirements as part of exercising that right?
The answer, in my opinion, is yes, and I would add to that while voting is a constitutional right, I personally believe that along with that exercising of that constitutional right, there does come some personal responsibility. In other words, and I believe that the courts would acknowledge this, that sometimes, the folks have got to take some kind of affirmative action in order to exercise that right to vote. And that's why we get into this balancing test of, what is an acceptable burden to place on the voter by the state. And we have talked about those four interests that a state has in placing that burden on folks. And so the responsibility, I think, also goes along with the right to vote. And that's something that, frankly, isn't talked about very often.
Thank you, Senator Newman. Senator Curran.
Madam Chair, when we get to the vote, I request a roll call. And Madam Chair, I also request that the record of the roll call vote be printed in the journal under the Senate Rule 12.10.
Thank you, Senator Curran. When it comes time for a vote, we will do that. Oh. Do we wait for that? I'm not. You do the show of hands now for the journal. Just to do this motion, right? Yes. Okay. We need to take a vote by show of hands in regards to this particular motion. All those in favor, raise your hand.
Just say aye.
Just have to count 3 hands, okay?
Madam Chair, I think you just
All
need
right.
3 hands
All right.
for that vote.
Thank you very much. First time doing it, so just a little different in my committee, and thank you for helping out. Senator Westrom, I got you down, and thank you very much. I think Senator Westrom, in the past, it's seeing 3 hands, correct? Thank you very much. Okay. So, Senator Rest?
Thank you. Senator Newman, Madam Chair, Senator Newman point out that the requirements for voting are not a matter of your opinion. They are in the Constitution. You have to be a certain age, you have to be a citizen, and so forth. So, I'm glad your opinion agrees with the Constitution, but the requirement is independent of your opinion. Also, lying is not a felony. people do it all the time. It's not a crime. When it's a crime is when you say, when you lie to an election judge in trying to vote when you're not eligible to do so. That's a felony. That's a felony. Lying is not a felony. Thank you.
Thank you, Senator Rest. Senator Rest, a question, though, sometimes comes up when you say that is lying. How would you know that they are lying? What would be the connection between what they say and their claim of what is true? I think that is more the pertinent question as I see it. And Senator Rest, would you like to add to your comment?
It would seem to me that a person that goes before election judge and lies about who they are knows ahead of time they're committing a felony. When you lie I don't know, when you lie to, when I lie to Jim Carlson here, about whether I'm going to be on time or not, that's not a felony. That doesn't rise to the level of seriousness of someone trying to exercise a right guaranteed to us under the Constitution if we are eligible to vote. So, Senator Carlson, when I say I'm going to be on time, he doesn't ask me to show him a photo of me with my name on it to ascertain that I am who I say I am, whether I'm telling him the truth or not. It's a very different situation and much more important for the person who is making the assertion. And our voting system in Minnesota allows that assertion under penalty of committing a felony. I think that is an enormous deterrent to lying to an election judge. Maybe other people don't think that's a deterrent. That a felony, a smelony, what difference does it make? I think it makes a big difference myself, and that is an opinion.
Thank you, Senator Rest. Though I have not seen any signs in polling places to some extent, so I don't know how commonly that is actually thought of, and especially by someone who might otherwise not tell the truth, but still, I appreciate your comments. So Senator Carlson and then Senator Gwazinski. Okay.
Yeah, thank you, Madam Chair. And I guess because it was brought up in the past, I need to be sure that I mention something that, when we cherry pick statistics, like the 312 votes that settled an election in 2008, when that person was reelected, that person got 53.15% of the vote, and there were 4 people in the race, and that person got more than all of the other candidates in that race combined. So there was an overwhelming reelection of that person, and we really should make note of that whenever we talk about the 312 votes, that person did get reelected overwhelmingly with well over 53% of the vote. And also in the 2008 election, there were 3 choices, and none of them received 50% plus 1 votes. So when the person got reelected, it was 53%, but the first time it was not even 40%, 42% by any of the candidates. Now, and I have a question at the end here, but I'm concerned that we're trying to solve a problem by instituting a system, and it's a new system that might encourage election fraud. Today, we have the ability to re-register right at the polls. We have the ability to self-certify at the polls. So you're voting, when you come into the polls, you can take care of your ID, any question on the ID, any flag that's in the poll books, you can take care of it right there and you can vote. And you do swear under penalty of perjury that you are giving true information. So if there is someone who disagrees with that information, they are perfectly free to fill out a complaint form and turn it in to the judges, and that the judges are required to turn it in to the county prosecutor, eventually gets to the county attorney. And they are required to investigate it. Now, what I don't hear is how many of those are happening around the state, how many are happening in each county. But when we have this new system, what we'll do is we'll encourage something that we've been trying to prevent, and that is getting into and monkeying with the voter file. And if we have the ability, if someone has the ability to hack in and put flags in there, they'll flag all the Carlson names, and nobody named Carlson will be able to vote without putting in a provisional ballot. That'll happen to me once because I won't vote anymore if that's what they do. So that's a real problem to me, that we will encourage these hackers to get into that system and play with it and make people so that they are no longer able to vote on election day because they will have to put in a provisional ballot, and that provisional ballot may not be cleared by the county. Now, my question is that, Senator Newman, if someone sees someone or suspects someone or has been told that someone is ineligible to vote, and you are told that, what is your responsibility?
Senator Newman?
Senator Carlson, I'm not sure I understand the question. Is the question posed to me as just any citizen? Is it
Yes.
posed?
Yes.
Okay.
Yes, Mr. Madam Chair.
I think that the responsibility, I guess my response would be, is it's the election judges that have to make that call, not me as a private citizen.
Madam Chair.
Senator Carlson?
So that means that somebody who knows about a felony has no responsibility to turn in that person who is committing a felony. For instance, if you see somebody that you know rob a bank, do you have any responsibility whatsoever to turn that name in?
Senator Newman?
It's a interesting, clever question. Does a citizen have a legal responsibility? And my answer is, from a legal standpoint, I do not believe that they do.
That's correct, yes. And Madam Chair.
Senator Carlson?
And the reason I'm asking this is in one of our most recent committee meetings, we heard two samples of people who said that they knew about someone who illegally voted. And I'd like to find out what was their reaction to knowing that this person, performed a felony, and there was no movement taken to turn that person in to be investigated or prosecuted. Because, yes, I believe you're correct, there is no personal responsibility, but there is a moral one. So I think that what happens when you see someone, in fact, that's what a person is supposed to do at the polls. It's a poll watcher. They're supposed to challenge people that are ineligible to vote. But after they vote, if you find out that a person was not a citizen, was not who they said they were, was a visitor to the United States, and they voted, I think that we morally are required to turn in that person.
Thank you, Senator Carlson. Personally, I think the system of elections owes it on behalf of all of the people of Minnesota to conduct a fair, honest election. So I think it's a system issue, and matter of fact, our Minnesota Constitution explicitly states in one particular area that they should not be allowed nor permitted. So I think there's a system issue here that on behalf of all the voters, we have all the election officials across the state of Minnesota, and it is their duty, they are sworn to uphold that as their first act when they come in to be an election judge and to work in the polling place on behalf of all of us as Minnesotans. But the system should be set up in such a way that they are able to do that part of their job. Senator Kwadzinski.
Thank you, Madam Chair, and I just want to tell you how much of a joy and a privilege it is to be able to finally speak here today. So
We're glad to have you here, Senator Kwasniewski.
thank you. And honestly, Senator Newman, I don't think you'll ever know how much I enjoyed listening to your testimony and your passion for trying to preserve the integrity of really this great experiment in democracy called America and the right to vote. We've heard words like privilege and right and sacred duty, my word, that hasn't been said yet. But nonetheless, you said earlier the more confident you are in the system, the more likely you are to participate. And I think we're going to agree that that's an important thing, but where we may disagree, I think the reason, as Senator Simon said, we have such a high voter turnout is because people are confident that we will, as a state, make every attempt possible to make sure everybody that is eligible to vote will not be discouraged to vote. And I think I got 3 quick anecdotes I'd like to point out, and I poured through your bill trying to find a way or an exception where these 3 anecdotes would be allowed to vote, and I haven't been able to see it yet. So as I go through them, maybe if you would say, no, I think this person would be allowed to vote, and I missed it, I'd love to hear that. And Senator Simon pointed out that his dad wouldn't have been allowed to vote because we got rid of the voucher on the day of the polls. And the first time I voted in Minnesota, I was 19 years old, and I just moved here, and I was living at the YMCA, and no, I wasn't having as much fun as the village people were. I kept looking around to see where this fun was, but it wasn't any fun. But the point is, I had no photo ID. I had no one to vouch for me. I had no bills. I was living, at the Y, and I went to this neighbor guy that I kind of befriended, and he vouched for me so that I could vote for the very first time as a 19-year-old Minnesota. I would hate to think that people in those shoes would be discouraged under this bill. The second thing, there were 2 recent fires in Minneapolis, one at the Drake Hotel and one on the West Bank at the high-rise. And if everything you own is destroyed in a fire, and it just happened to be the eve of an election, would you just the next day be, wow, I've lost this sacred duty, this sacred right, because my possessions all went up in smoke? And thirdly, my wife recently had her purse stolen, and everything in there, all of her IDs and everything, or her photo IDs were stolen. And so if that happened on the eve of an election, would she be not allowed to vote under this bill the next day? So those are, I guess, some anecdotes to,
Madam Chair.
Again, I just want to applaud you on your testimony today. Thank you.
Senator Newman.
Thank you for those questions, Senator. First, as to the statement of the electoral process having an independent significance, those are Justice Kennedy's words, not mine. I happen to agree with them. But what he said was public confidence in the integrity of the process has an independent significance because it encourages citizen participation. That's what Justice Kennedy said. I think he's right. And it is one of the 4 state interests that a state has in adopting a photo ID requirement. We aren't talking about just fraud. We are talking about the modernization of the system and the encouragement of citizens to participate. To your question, in the event of a 19-year-old who doesn't have the documentation, in the event of the fire, in the event of the stolen purse, this bill provides a method for them to vote. Nobody will be disenfranchised under this vote because in all 3 of your examples, in the end, if they cannot, for whatever the reason is, come up with the necessary photo ID or the underlying documents necessary to get the photo ID, they are required to sign an affidavit stating that fact. Why is it that you can't come up with the documents? Their vote is then counted. So in all 3 of your examples, Senator, the person gets to vote and the vote is counted.
Thank you, Senator.
Thank you, Madam
Members, we are at the beyond the end of our time. Senator Lane, I'm going to give you the last one, but it needs to be very brief because another committee will be in this room shortly.
Thank you, Madam Chair. I just want to make a statement, and I'm basing it on your 4 points of the legitimate state interest. And I'm just going to quickly say that voter fraud, I am not aware of any here. Preventing voter fraud, again, what is the problem? And the impersonation, you yourself said that it's extremely rare, if at all. And then the safeguard voter confidence, and we in Minnesota have shown our extreme voter confidence by being #1 in the nation for several years. So the burden that is added, the disenfranchised that is possible, the cost not just to the person but to the system. We know how much it costs per ballot for a person to do an absentee vote because it goes into this envelope, goes here, it goes there. Now you're having that for the provisional ballots, which will be way an increased number, and all of this for no reason. As our 2012 constitutional amendment showed, we have no reason to do this. That's my opinion.
Thank you, Senator Lane, and I'll go to you, Senator Newman, for any closing comments.
Yeah, I think we've had a lively discussion. It's fine. I won't make any closing comments. I think folks know exactly where I stand. With that, I believe, Madam Chair, the appropriate motion would be that I move that Senate File 3571 as amended be recommended to pass and be re-referred to the Committee on Transportation.
Yes, Senator Newman, that is the correct motion. On that motion, we'll have a roll call vote, and the clerk will take the roll.
Senator Kiffmeyer.
Aye.
Senator Curran.
Aye.
Senator Carlson.
No.
Senator Swedzinski.
No.
Senator Howe. Senator Jasinski.
Aye.
Senator Lane.
No.
Senator Newman.
Yes?
Senator Rest.
No.
Senator Westrom.
Yes.
Senator Howe.
Okay, we have 5 votes for and 4 against. The motion does pass, and Senate File 3571 as amended will be sent on to Transportation. Thank you very much, members. And with that, our committee is adjourned.
Madam Chair.